Okay, this video is going to cover Chapter 2, PowerPoint, over the tort, civil liability, and some basic standards there. First off, I just want to offset it from criminal. Criminal law violations, which we won't deal much with here, usually involve intentional acts. So, and they're in what are called penal codes or penal statutes. Penal is the root word for penalty. So, murder, rape, arson, burglary, kidnapping, fraud, drug crimes, etc. The punishments there are punishments, and usually incarceration, probation, fines, penalties. Again, you see the word punishment and penal in there. Torts are more about liability and what's called compensation. So, for example, if I come to your car and I smash in your window on purpose, I both have to pay for your window or my insurance, and I might also get in trouble for vandalism, right, or criminal mischief. If I'm skateboarding or something, that's a hypothetical, and then I fall off my skateboard and take a header into your driver's side window, and I smash your window. Well, now I have to pay for your window still because I broke it. My carelessness, my mistake broke your window, but I'm not going to get punished for it, right? I guess you could argue punished. I got punished with a concussion, but that's not from the state. So that's civil versus criminal, all right? So tort is a French word. It means like a civil wrong, meaning not a criminal wrong, but a civil wrong, a negligence, accident, all of that. Now, there are three basic types of civil cases. You could generally argue anything not criminal is civil, but for our purposes in this chapter, negligence, which means basically an accident, intentional torts, which are the liability that attaches usually to criminal activity, things that you do on purpose, a mental state, and then things like product liability and all of that. So those are the three basic kinds: negligence tort, intentional tort, product liability tort. But there are other civil violations like contract law and those kinds of things. All negligence lawsuits have four basic elements. You have a duty. One is a duty. Two, you have to breach the duty. So you have to do something that violates your duty that you have under the law. Fourth, I'll just go down to four, you have an injury, a legally recognizable injury. So physical harm, harm to property, money damages, which is what we usually do in the United States. And then the third one is actually a connection. The breach has to cause the harm. So those are four basic elements: duty, breach, causation, harm. Crimes have elements too, but that's the basics of a negligence tort. Now, the PDF article after Chapter 2 talks about a standard of care. It's a law review article. That's an example of what I mentioned in the other video. That one deals with athletic trainers. The general principle is accurate, that athletic training does have its own standard of care. The caveat or the warning I would give to you folks, because I don't know that any of y'all are athletic trainers or going to be athletic trainers, is the standard of care depends on your field. So there would be a standard of care for cross fitness instructors, let's say, or fitness instructors. There would be a standard of care for physician's assistants, for those kinds of folks. So it kind of, what is your field of endeavor, and then whatever state you live in, because it is state to state, right? There's 50 states, so each state's going to have its own standard of care. So whenever you move, one of the first things you need to sort of figure out, okay, who am I licensed by? Am I licensed? Do I have to be licensed? Whom am I licensed by, right? And there's always a fee and education and all that sort of stuff. And then in those, there'll be regulations which will cover. So usually it runs along, this is in the article, what is the standard of care of a reasonably prudent or reasonably cautious fitness instructor or athletic trainer in the case of the article. And it's a higher duty than me. So for example, if I'm coaching a football team, little league, whatever, youth league, and I'm leading them in calisthenics or some drills, I'm going to have a different standard of care than someone who's a certified fitness instructor, right? Why? Because they're a specialist with all the education and stuff that comes along with that. I'm a volunteer, coaching a bunch of 9-year-olds or 10-year-olds or whatever. So you kind of have to look at that always. So, but the basic principle is, and you read that article about athletic trainers, is just kind of plug in your own career path, and if you will, if it has a job title or a specific name, and then whatever state you live in or are going to practice in, then find that standard of care. You can do a legal search through Nexus Uni. What's the standard of care for this and that, and they'll might find cases that'll mention it. You can go into Google. Actually, Google Scholar is good too, quite frankly, and type in California standard of care for X, whatever X is, right? And you can start kind of finding. And then, as I always say, my big advice to you is ask a lawyer who deals with those kinds of cases. So I'm a generalist. I teach law. Obviously, I know the general concepts, and I can speak pretty well on a lot of areas, but you always want someone who represents you and your interest to sort of give you legal advice. So keep that in mind. My other advice to you would be get insurance. You can get it through homeowners policy. It's called an umbrella policy. You can get a liability policy. My wife, for example, is a photographer. She's got a liability policy of $1 million. It's like, I don't know what the price is. It's like $50 a month with State Farm. There you go. I said it. But that may be more or less, but you can get policies to cover you. Your professional associations, your unions, those kinds of things will oftentimes have legal protections. That you can hire a lawyer through them, your insurance company, as I mentioned. I'd also hire your own lawyer. Don't ever let your employer hire a lawyer for you. Hire your own lawyer. Get your own lawyer. Trust me. Anyway, so that's that. So negligence tort is the standard of care, breach of duty, causation, injury, or what we call damages or money damages, is the main one. So you can get into all sorts of things of standard of care and all that. Gross negligence means like really negligent. So if someone shows up to work drunk and causes an injury, or high, or just blows through something that any blithering idiot would have gotten and they just missed it, right? So it doesn't have to be intentional, but willful, wanton, reckless, that usually means you're like the guy in the submersible thing a couple of weeks ago, right? To me, that's reckless. Did he intend to kill all those people on the boat plus himself? I highly doubt it. Did he cut a lot of corners? Yeah, and that's reckless. And that's why his estate and his company, they're going to get sued into oblivion, because that's recklessly negligent, grossly negligent, right? Gross means excessive. Intentional torts would be battery. So battery is like an unwanted touching. So again, you're talking like aggravated assault. In California, we call the crime battery. So there's a crime of battery. There's also the civil tort of battery. So for example, in a criminal case, let's say someone with sexual intent, we might say in the law anyway, pinches somebody on the backside, on the rear end, or grabs them or fondles them or whatever. From a criminal standpoint, that might not be considered serious. I'm not saying it's not. I'm just saying in terms of jail time, you're talking probably probation, probably not a huge fine, and all that sort of stuff. But in the civil lawsuit, you might be talking thousands of dollars of damages if the company doesn't handle it correctly, and all of that. And let's say the person's traumatized by it, right? So in criminal law, the punishment's not going to be that much. But if it triggers some trauma from past trauma, maybe the victim was, sexually violated when they were younger, or a victim of abuse, or something like that, and all of a sudden this intentional act of being sexually battered triggers this response. Now they need counseling for 6 months or a year or whatever. It triggers a physical response. All of a sudden your damages start racking up, right? So then the lawsuit would then the compensation for those damages. So that's what an intentional tort could do, right? O.J. Simpson is the perfect example. He's charged with the murder of 2 people. He wins. Don't even get me started. But then he's sued by the survivors of those two people, and then he's sued for $33 million or whatever for wrongful death, right? So, and he's liable for that. The standard of proof is preponderance of the evidence, which means more likely than not. So the criminal standard of evidence is a lot higher. Preponderance of the evidence means I have to bring in enough evidence to tell a jury that it's more likely than not that my client didn't do this, or excuse me, that the defendant, it's more likely than not that the defendant, is liable for the injuries that my client suffered. And then let's see, they give you a ton of different of things here. In terms of product liability, you generally have two kinds of product liability. You have a lot of warranties, that you get 90 days, same as cash, 90 days back, 30 days to return, all that kind of stuff. There are implied warranties. I mean, you might have a 3-year, 36,000 mile warranty on a car, but if your engine throws a rod at 50,000 miles, you might still be able to sue Nissan or whatever, because it's a motor. Your motor should last 100,000 miles at least, right? Those kinds of things. So there are also design defects. A design defect is like the design of the product itself is flawed, and then of course there are defects in manufacturing, which means the design is fine, the factory screwed up. So there are two basic lawsuits there as well. And then on a note on defenses here, so assumption of the risk is often a defense in these cases, especially in sports cases. So, if any of you are parents or any of you have coached sports, you get kids to sign waivers. Some of you played college sports, I get from your videos. Down there in the paperwork, you signed and waived away the right to sue the university for whatever. Now, of course, they have an obligation to provide health care, provide a proper training regimen, fitness and weights and access to food and all that kind of stuff. But you also assumed, okay, I know if I play football, I might blow out my knee and never be able to walk regularly again because I'm going to have an arthritic knee or whatever. So the university and the high schools and all that are supposed to provide a certain standard of safety. But of course, football, hockey, lacrosse, soccer, etc., they're all inherently risky. So you assume that risk voluntarily, right, of free will. So anyway, that concludes chapter 2.